Be ready. Start. Yet another facet of the issues involved in these appeals is the writ petitions filed by the banks and financial institutions to safeguard their interest in regard to attachment and sale of the properties of the appellant mill. The said writ petitions were considered by another learned judge of the Madras High Court, who, by his order dated 12th July 2005 in PNL Investors Welfare Association versus Union of India, with reference to the Sarfacy Act, the Sikh Industrial Companies Special Provision Act 1958, Act 1 of 2005, and the provisions of the Industrial Disputes Act 1947, and in particular Section 25 FF thereof, disposed of the writ petitions upon holding that the members of the workers association stroke workers, either individually or through their respective unions, were entitled to the benefit available under section 25 FF of the 1947 Act from the appellant mill and Perry Limited in view of section 13(6) of the Sarfacy Act. In the same order, the learned judge directed the members of the Depositors Association and others to avail of the remedies provided under the Sarfacy Act as well as Act 1 of 2005 for necessary reliefs. The said decision of the learned single judge was questioned by Perry Limited and the Commissioner of Central Excise, Pondicherry, who filed WA numbers 1787 of 2005 and 1999 of 2005 respectively, claiming that the department's claims were superior to those of others against the appellant mill and its properties. Apart from the submissions relating to section 25 FF of the Industrial Disputes Act 1947, what we are really concerned within these appeals is with regard to the validity of the Pondicherry Protection of Interests of Depositors in Financial Establishments Act 2004, Act 1 of 2005, and GO-MS number 12 dated 18 to 2006 issued by the Department of Revenue and Disaster Management. As indicated herein before, the object of the Act was to protect the interests of depositors in financial establishments in the Union Territory of Pondicherry. The division bench of the High Court observed that inasmuch as the Tamil Nadu Protection of Interests of Depositors in Financial Establishments Act 1997 were in pari materia with the provisions of the Pondicherry Act of 2005 and the provisions of the Tamil Nadu Act had been upheld, nothing further was required to be gone into in that regard. A question of considerable importance also came up for consideration in the appeal filed by the government of Pondicherry with regard to the observations of the learned single judge in writ petition number 1897 of 2006, wherein the learned single judge, while upholding the validity of the enactment, went on to observe that the impugned enactment was made only in relation to unincorporated trade establishments, and the state legislature of Pondicherry had legislative competence to legislate in respect of unincorporated financial establishments only. In this regard, a submission was made on behalf of the government of Pondicherry to the effect that entry 32 of list 2 of the 7th schedule to the constitution was only a residue of entry 42 in the central list, and that entry 32 also covered incorporated companies. It was submitted that the learned single judge had erroneously held that Pondicherry Act 1 of 2005 only governed unincorporated trade establishments. In this regard, it was submitted before the Madras High Court by the learned government pleader that on a complaint received by the Pondicherry police from one Bhuthanathan alleging that the amount deposited by him in PLN Nidhi Limited had not been returned, the Pondicherry police registered a case in crime number 31 of 2004 on the file of the CID Pondicherry, which took up the investigation. Subsequently, about 3,000 complaints were received from mostly aged people and retired government servants who had invested their savings in the various financial establishments. Any person or group of individuals or a firm carrying on business of accepting deposits under any scheme or arrangement or in any other manner but does not include a corporation or a cooperative society owned or controlled by the government, any state government or the central government, or a banking company as defined under Section 5 of the Banking Regulation Act 1949, referring to the statement of objects and reasons in the enactment of the Pondicherry Act 2004, Mr. Ganguly pointed out that it had been specifically indicated that there had been a mushroom growth of non-banking financial establishments and deposit taking unincorporated bodies not covered under the Reserve Bank of India Act 1934 in different parts of the country. Thank you.